Good morning, everyone. We do apologize for the technical glitch on our side. We believe that a few of our brokers couldn't join in on the first couple of minutes. I am Lucia Swartz-Horn, Senior Claims Specialist in the Claims Department here at iTOO. This morning, I'm going to be joined by Jean Lodier, Director at Independent Claims. Our topic up for discussion this morning is defective, damaged, or dangerous, the different phases of product liability. Jean will be touching on a couple of examples on the different aspects of product liability, how liability policy would work and apply or respond to such scenarios. Also, some risk mitigation strategies. While we all know that the Consumer Protection Act clearly outlines consumer rights, product liability claims can be complex and each claim needs to be assessed on its own unique circumstances. Jean, I'm handing it over further to you. Just to quickly advise you as well, we will take questions after the discussion. Please be free to post your comments in the panel for questions and answers, and we'll get to it at the end of our discussion. Thank you. Over to you, Jean.
Good morning, everybody, and thank you very much for joining us. We are very, very excited to have you on this Tuesday to discuss this very topical question and into what types of cover are available, what type of protection is available, and how all of these slot together to form an impenetrable protection in the form of a wall, as you'll see in a couple of slides later, for insureds out there, especially with consumerism being the order of the day. This little boiler bird will form the subject of an example that I will be providing a little bit later and sets the scene. It is always essential in a discussion of this nature to perhaps just revisit the roots of where product liability actually originated from. And as you would have guessed from these images in black and white, this is typical of what the industrial revolutions have over the years brought about, and the advancements in production, manufacturing processes, etc., up until where we find ourselves at the cusp of the fourth industrial revolution. So if you forgive me, just a couple of remarks about the industrial revolutions. As you're no doubt aware, we had 4 in total to date. We actually just entered the 4th one. Just to revisit, let's take a step back. The first industrial revolution was actually commenced in Britain towards the late 18th century and was characterized by a period of major economic change. In essence, it changed the way that products changed hands. From the outset, we had the exchange of agricultural goods for something somebody else could produce. Argument's sake, I'll swap you a fish for a pair of shoes, vice versa. And that, of course, over the years have developed to what we have today. And it was brought about by the revolutions, as I mentioned earlier. So handcrafted agricultural goods had to make way for machine-produced items on a mass scale. Didn't come without growing pains. If we think about pollution and coal-fed machines to where we are today, where everything is supposedly cleaner, greener, etc., you can see where I'm going with this insofar as a talk on product liability is concerned. But we cannot ignore the impact that steam engines and things like spinning jennies have made on the manufacturing of clothing lines, for instance. But in essence, what this has brought about was assembly lines and the mass production of products. So gone are the days where something was made by hand, where the actual manufacturer or producer could quality control every item he or she made, and that had to make way for mass-produced items. All right, so that explains the first and the second phases of the Industrial Revolution. The third revolution, Industrial Revolution, was characterized we are today, where everything is almost electronic based, and it brings about its own problems. Very exciting times, as my teenagers will remind me from time to time. You've got everything you need in your one hand by virtue of the smartphone of yours, and I cannot argue with that, other than the fact that what I've seen in my line of work is that on a mass production scale, the impact of if something goes wrong is also obviously exponential. And can we forget the issue of the shortage of chips, electronic chips that is, on our daily lives? So definitely not without growing pains. And of course, the fourth revolution is brought about, or is characterized by the Internet of Things, the cloud, which I still don't understand where this amazing place is, cyber systems, and robotics. We've seen that Elon Musk has now introduced the first butlers, in inverted commas, that is an assistant in your household, where you can give instructions, different to my wife in the mornings, a smile on the dial. But this is where we find ourselves at the moment. Very exciting times, as I pointed out, but for insurers and insureds out there, also trying times, as we will find out in a couple of minutes. So what can one do to mitigate against the risk of financial ruin caused by mass-produced items? One of the strategies that insureds can import, obviously not necessarily insurance related, would be research and development to produce products of the highest possible standards. The second strategy could be the sourcing of the required skills and quality raw materials to produce a product that does not fail or does not become defective and give rise to injury or damage to third-party property. A third strategy could, of course, be compliance with industry norms and standards. As we've seen in South Africa alone, we've seen over the years development in this arena where the legislature has taken the forefront and introduced legislation to protect us as consumers against the harmful effects of defective products. The Consumer Protection Act, as Lucia mentioned earlier, being but one of these pieces of legislation that has been put in place. Occupational health and safety, we have foodstuffs, we have Act 36 of 1947, which we'll touch on a bit later, that deals with agricultural products in the form of chemicals, agrochemicals, and animal feed. So there is the strategy from an insured to comply with all of these standards as a mean to prevent a defective product leaving their assembly or manufacturing facility. The next strategy is, of course, robust quality control processes, which has become very, very important. One of the first questions that the media would ask a manufacturing event of a recall action, for instance, is, can you explain how this could have happened if your quality control process was as robust and effective as you make it out to be? So a very important strategy. A lot of time, energy, and resources are being spent today to make sure that we have a robust quality control process. And of course, when you have a manufacturer or a manufacturing department and you have a procurement department that do not necessarily engage. It's of course very important for quality control to make sure that all of these elements and components of the process actually make sense, and that a quality product is produced and is distributed into the market. So a very important risk mitigation strategy. Apologies, a bit ahead of myself there. A further strategy would be the effective identification and isolation of defects. And the reason why I add that is the effectiveness comes in that if it's identified, and that's obviously hopefully before it leaves the insured's warehouse, and isolated, the insured will be in a position to actually, by virtue of their research and development, discover why the product became defective in the first place, why there was perhaps an anomaly on some product lines, or why some products just failed prematurely when in service. So very important risk mitigation strategy is to identify, isolate, and then improve on the blueprint of this particular product. The next strategy will of course be, once there is non-adherence with the product specification, or if this item actually exits the warehouse, it's distributed to the end user by virtue of a retail network, then it's very important, once this happens, to mitigate the extent of one's potential exposure, to trace from a traceability perspective the whereabouts of these products, which is very important, and examples will be given a bit later. The consumer must be informed by virtue of effective communication, and we've seen that in the listeriosis matter a couple of years ago. That's again become quite topical recently, where the Consumer Commission, after they instructed the manufacturer to recall certain products, the steps taken by the relevant manufacturer to actually trace and isolate and quarantine these defective products. And that was done by virtue of effective communication. Went out to retailers, went out to distributors, and thousands of tons of product was in fact recalled from the market in a very short space of time, which speaks towards the traceability aspect, as I mentioned earlier. And then, of course, very important, damage control. And I've seen this in loss adjusting, where effective damage control is a major contributor towards the mitigation of the potential exposure of a manufacturer or a retailer. And the damage control can be undertaken, of course, internally, and there's also external contractors that specialize in assisting a manufacturer or a supplier, retailer, in doing this damage control. So very important strategies that need to be considered. And that brings me, of course, to our topic today, where one of the major strategies that an insured can take is to transfer the risk of financial ruin in the event that there is in fact an allegation or an actual case of a defective product leaving its assembly lines, warehouses, or entering its distribution network, by effecting adequate insurance cover. I've also mentioned the word appropriate, so two distinct topics, and we'll delve into what appropriate and adequate then of course means. So looking at the image on your screen, this is my representation of what your, and forgive me using the term entry level, product liability insurance cover would look like. we can see that this residential residence is in fact covered by a very well designed roof covering, but the protection provided can be so much better. In the next slide, you'll see that if one also elects to effect product inefficacy insurance cover, it adds another layer to the protection already provided. Regrettably, there are a couple of entrances to the residence that are not protected by this seemingly very sturdy gabion wall that has been used by or spec'd by the homeowner. So the next level of protection would, in my opinion, be provided by products recall and products guarantee insurance cover. I think you'll agree that perhaps not aesthetically as pleasing as the first residence, what you see on your screens is now almost impenetrable residence providing adequate protection against outside threats. The question that I have from time to time is, well, is there anything else that an insured can do to mitigate against the risk of potential financial exposure? And that, of course, comes in the form of appropriately worded terms and conditions. Now, this could be your first line of defense, of course, when in a scenario where a customer applies for credit facilities, you incorporate your terms and conditions into the application for credit facilities, and these terms and conditions provide protection against indirect and direct claims. Now, the distinction between those two terms is very important. In the majority of cases, it's not necessarily the direct damage that can cause financial ruin, but rather the indirect or consequential losses suffered by a customer that could be exponential and can very quickly erode whatever resources you have to defend yourself against such claims. So terms and conditions are extremely important, despite the fact that there are opinions out there that dictate that the Consumer Protection Act has nullified the effect of any terms and conditions. I've seen in a number of occasions where T's and C's have been ruled to apply and to provide protection against indirect / consequential losses, to great relief of both insurers and to the insured. And then, of course, the Rolls Royce of the risk mitigation would be in the form of adequate limits of indemnity. It goes without saying, dear audience, that if we have a policy that provides almost comprehensive cover, as you've seen in a slide or two earlier, the limit of indemnity or an inadequate limit of indemnity can undo all of the great work that was put in place to mitigate against financial ruin. If the cover is only for 1 million or 5 million and the exposure is 50 million, then it goes without saying that that creates a huge problem and potential exposure for the insured if the cover is not adequate to provide protection against claims. Apologies. So having said all that, let's then perhaps look at the cover that is provided under a typical products liability insurance policy. Questions that usually arise when I have discussions of this nature is there any similarity then between public liability and products liability cover? And the brokers would ask, Ron, my client insists in only having public liability cover. under a comprehensive or an umbrella program, is that not adequate? And the answer is obviously quite evident from the slide. Although there is a commonality insofar as the cover provides both indemnity against injury to persons or damage to third-party property, the public liability insurance policy is aimed at providing a general type of cover. And by general, I mean cover that would typically apply where, and I think the word public perhaps gives it away. A member of the public, for instance, walks onto your sales floor, slips, trips, and sustains bodily injury. So the indemnity provided under the public liability policy is aimed at addressing personal injury or potential damage to third-party property. If there's, for instance, an expensive watch that is shattered in the process as a result of the insured not clearing perhaps a oil spill, or if there's a protruding tile that creates a potential hazard for pedestrians. So it's intended to address scenarios arising from the general business activities and services provided by the relevant insured. Product liability, on the other hand, is aimed at indemnifying an insured for damages claims arising from the supply of any product that was sold, supplied, or manufactured by an insured. So I think you can see the distinction between the two types of cover and why it's necessary to have both. But our discussion today is focused on expanding on our knowledge of what product liability typically covers. So whereas the entry level, as I mentioned earlier, product liability cover provides indemnity for injury or damage, we need to see if there's something else that we can also add into the fold to provide added protection. So looking at the iTOO insurance policy, and forgive me, I'm going to read out of their wording. The cover states as follows: we will indemnify you in accordance with the indemnity agreement for claims first made against you during the period of insurance for your legal liability for damages and claimant's costs and expenses for and arising out of. And I just want to stop there. You would have seen that I've highlighted your legal liability and damages and claimant's costs and expenses. Now, the reason why your legal liability is emphasized is basically to confirm that sources of legal liability covered by the policy includes delict and contract. So if there is an agreement concluded between two parties and party A seeks damages against party B arising from the supply of a defective product, then of course that would create the legal liability referred to. Alternatively, in delict, if there is no causal connection or no contractual connection between the parties, then of course the third party will make use of an equivalent action or a delictual claim based, apologies. They will make use of delict to submit a claim against the insured, and of course they would have to prove the 5 elements of a delict to succeed with the claim. Then turning to the second part that was highlighted or emphasized, the cover provides for damages and claimant's costs and expenses. So it is important to note that the indemnity provided by the policy is twofold. On the one hand, we have a scenario where a third party is successful in proving that the injury or damage was caused by a defective product. In such case, assuming that all of the other conditions of the policy had been adhered to or complied with, the cover will provide for compensation in the form of payment of capital for the third party's claim. Is the capital portion, and of course there is cover against the expenses that the third party incurred by virtue of attorneys, etc. Now, the other leg to the indemnity provided is also extremely important to note. So, where a claim is made against an insured and the merits suggest that this claim is defendable, then the policy will also provide indemnity against the cost of defending an insured against such allegations. So it's very important to note these two legs of a policy. It's not just a question of what the product has to be defective in order for the cover to apply. There's also the protection against financial ruin that is possible due to the high cost of litigation. So one effectively provides or effects cover for defense costs. Right, then proceeding to the first insuring clause, namely product liability, the cover will be as follows: bodily injury or property damage suffered by a third party caused by the nature or condition of your product. Now, this makes it very clear that in order to succeed with a claim under the product liability section of a policy, an insured would have to present evidence that a third party has suffered bodily injury or property damage as a result of the nature or condition of the product produced, supplied, or sold by the insured. The policy provides for a definition for both of these terms. In the case of bodily injury, it means death, physical injury, illness or disease, loss of immunities, emotional distress, or invasion of the right of one's privacy. Alternatively, it also provides cover for property damage in the event that there is evidence of physical damage to or loss of or destruction of property, interference with the servitude, or other infringements of real rights. So, to recap, in order to succeed with a claim under the product liability section of the policy, there must be evidence of either bodily injury and or property damage as a result of a product. Now the question then of course arises, well, what happens then, John, if there's no evidence of injury or damage to third party property? Is that where this bus stops? And the answer is fortunately no. If one considers the product provided if one considers the cover effected by the products in efficacy section of the policy, then we can expand on the cover provided. Now, as you'll see on your screen, I've actually listed the definition of product as well. It's not intended for us today to delve into what exactly a product entails. The most important item to bear in mind is the fact that it's a tangible item, but it's a tangible item that is in fact left the insured's custody or control. And it's a very important point to note. So we get from time to time cases where we're confronted with a scenario where a motor vehicle, for instance, is worked upon in an insured's workshop, and there at one stage is a requirement to replenish the oil in the vehicle, and the technicians go on tea break, they omit to replenish the oil, and upon cranking the engine to move it from one section to another, catastrophic engine failure occurs, and there's of course damage to third-party property. The question arises, is this now a public liability or a products liability related claim? And given the fact that the definition of a product requires a product to leave the insured's care, custody, and control, it makes it quite clear that it cannot be a product's liability claim because the vehicle was damaged while still in the insured's care. So from that perspective, one needs to note the distinction brought about by the definition of a product. And then you'll see from items A to C that it is sufficient for your insured to have altered or serviced or repaired or even erected something to constitute a product. So it's not just an event where an insured would be covered for items that were manufactured. It's also by altering the state of a product or treating it or installing it that creates possible cover under the product liability section of the policy. All right, then I have noted two very important exclusions, and the reason for these exclusions will become apparent in a couple of slides. The cover provided under the product liability section specifically excludes C, the failure of a product or any part thereof to fulfill the purpose for which it was intended, or to perform as specified, warranted, or guaranteed. And then there's an extremely important but. And I continue. This exclusion does not apply to consequent bodily injury for property damage. So just to unpack that for a second. So where a product fails to fulfill its intended purpose, but there is no injury or damage as a result of this failure, then the exclusion will apply, and we will address alternative cover in a second. However, if the product fails to comply with its intended function, basically contrary to its specification, rendering it defective, and such defect give rise to injury or damage, then that is exactly what this section of the policy intends covering. It follows logically that if it doesn't fail to perform as specified, the injury or damage would not have occurred, because then obviously it performed as it was intended to. The second exclusion that is rather important is the cost of recalling, removing, repairing, replacing, reinstating, or the reduction in value of any product if such liability arises from any defect therein or the harmful nature or unsuitability thereof. Now, the reason why I highlight this exclusion is that alternative cover, of course, exists in the form of product inefficacy, recall, and guarantee cover. All right, so having dealt with, in a summarized format, with products liability, we can now move over to an additional bolt-on, as we've seen in the previous couple of images ago. We are now providing a little bit more substance to the protection provided in the form of product inefficacy. Now, product inefficacy, and I'll read it to you, provides the following cover. We will indemnify you in accordance with the indemnity agreement for claims first made against you during the period of insurance for your legal liability arising from any third party alleging that they have suffered economic loss by reason of property other than your product being rendered of less value, rendered incapable of full commercial benefit, alleged other than by you to be due to the failure of the products to perform as specified, warranted, or guaranteed, and or to fulfill their intended function. And we agree that we will not raise as a defense to granting indemnity by this policy in respect of this specific section that no loss of property or property damage has occurred. Now, obviously, that is a mouthful. Can I unpack it as follows? When we are confronted with a scenario where a defective product has left the insured's manufacturing line, warehouse, retail shelf, etc., and a claim is presented to insurers for consideration, the first question, one of the first questions that will be asked is whether or not there was injury or damage caused as a result of this defective product. If there is no allegation of injury or damage, but rather a financial loss suffered by a third party, then it becomes quite evident that this type of claim and the allegations contained in the letter of demand will not fall for consideration in terms of the products liability section of the policy, but potentially under the product inefficacy section of the policy. So what it entails, or what the cover entails, is basically financial losses suffered by a third party as a result of the acquisition of this product from the insured. So insurers indicate that they will not raise the offences of non-compliance with either the absence of injury or the absence of physical damage to third-party property when they're considering the cover provided under inefficacy. The requirements are simply that the third party would be required to substantiate and prove that their property, that is property other than that which was acquired from the insured, is now being rendered of less value or rendered incapable of full commercial benefit. Now, of course, questions from the floor will arise. Well, Jean, give us an example of when this happens, because it's becoming very technical, and we need to see this in order to grasp what the cover entails. And unfortunately, I'm not going to put you to a next session. I'm going to explore the examples by virtue of a couple of images a bit later. But just continue with this discussion. Keep that in mind, that your insured needs cover in the event that there is no evidence of injury or damage as a consequence of a defect in this particular product. So bear with us. We'll assist with examples in a second or two. All right, so the next level of protection is of course provided by your product's recall section of the policy. And again, I'm going to read the wording for you. It states as follows: notwithstanding anything to the contrary contained in section 2, namely products liability, specific exclusion D, excluding recall, which we covered in a slide or two ago, we will indemnify you in accordance with the indemnity agreement against loss in excess of the deductible, but not exceeding the indemnity stated in the schedule resulting from an insured event that first takes place during the period of insurance. Okay, so now it is evident that under recall, there is a specific insured event covered against. There seemingly is no requirement for injury or damage if you read the recall section, and an example will also be provided in a second or two. Then the last form of protection by virtue of policy cover is the infamous products guarantee section. And this section is possibly one that gives rise to the most, I don't want to call it heated discussions, but we have a lot of different views regarding what the products guarantee section actually entails. Once again, I'll just read the section for you, and then we can delve into a couple of examples. All right, so the cover is as follows. We will indemnify you in accordance with the indemnity agreement for claims first made against you during the period of insurance for your legal liability for damages, and claimant's costs and expenses for the removal, repair, alteration, treatment, and a very important, or replacement of any product which is due or alleged to be due to the effective or harmful nature of any product or part thereof, or which fails to perform the function for which it was manufactured, sold, supplied, installed, repaired, altered, or treated by you on or on your behalf. Okay, so having dealt with all of the technical aspects and dealing with all of these different types of cover, can I just crystallize it in a couple of slides? So, in a case study involving our broiler birds, and I think this is possibly the best example that I've come across in the number of years that I've been dealing with products liability and related losses, would be the supply of animal feed to, in this particular case, broiler chickens. So in this slide, you'll see this is our manufacturing facility where we produce, amongst others, a broiler feed. Now, broiler, of course, is your little day-old chicks that are placed in houses up to 50, 60, 100, 200,000 at a time. There may be 5 or 10 of these houses on one of these production farms, and these broiler birds are reared over a period of 32 to 36 days when they are now in a slaughter, or they reach a slaughter weight, sent to an abattoir where the necessary is done, and we then benefit from the carcasses by virtue of getting our drumsticks, etc., etc. And apologies for the members of the audience that do not consume any meat products. But I think you'll understand the example in a couple of seconds from virtue of these slides, examples. So the product produced in this manufacturing facility, upon completion of the manufacturing process, is then distributed to these production farms by a vehicle, usually in the order of 36 tons per consignment. And upon arrival at the production farm, the feed is then pumped into mini silos, and from there the feed can then be distributed to all of these different houses. If you haven't seen what a broiler facility looks like, this is typically a broiler house where you may have thousands and thousands of the broiler birds, as we refer to them, and they are reared. So the question then arises, if there is a defect in the feed supplied to these broiler birds, and the extent of the defect results in either the demise of these birds, alternatively, for birds not to die or to succumb to the ingestion of the feed, but rather to fail to achieve the carcass weight that the owners of this production farm expected. The question arises, well, what type of claims do we typically see in the industry? So if we bear in mind that the cover provided under the product liability section has a requirement of injury or damage to third-party property, then, in my opinion, by feeding these thousands of broiler birds a product that gives rise to an increased mortality or completely wipes out this entire flock, then I think we will all agree that we're now typically dealing with a product liability claim, because a third party would be able to demonstrate that as a result of using the defective feed to rear these broiler birds, and the broiler birds died as a result of consuming the defective feed, that a financial loss has arisen due to the demise of the birds. So that on the one side would explain a typical product liability claim where there is a loss caused by the demise of broiler birds, and broiler birds, of course, being the third-party property. If, however, the feed or the nature of the defect in the feed is as a result of the non-inclusion or inadequate inclusion, of argument's sake, something like calcium or a vitamin B6 or a B12, which is very important for these little chicks to develop strong bones and to flourish in this 36-day cycle, then the scenario is as follows. The birds would not necessarily die, but they will fail to achieve the economic value that was expected. And this, if you cast your mind back to the cover provided under the product efficacy section of the policy, is exactly what cover this insured would require in order to address a claim from the owner of this particular production facility by stating, Mr. Manufacturer, you've supplied us with a feed that resulted in a reduction in carcass weight from, argument's sake, 1.8 kilograms to 1.6 kilograms. So the difference in weight, namely 200 grams, would basically constitute our loss. And this is why it is so important for manufacturers to effect product efficacy cover, because this scenario will typically be covered by this section. No injury or to persons, and no damage to third-party property per se. It becomes very interesting when, of course, we have a scenario where some birds succumb and some birds actually survive. And that's when you get very clever vets that would dissect birds and check if there are any damage to organs, etc. And then, of course, that section of the bird population will transfer to the products liability section as well. A bit technical, but that's how these type of issues are resolved in practice. All right, so hopefully that explains the differences between your product liability and your product efficacy cover in the scenario provided. The next question then arises, well, does the extent or the potential exposure stop for the manufacturer by addressing either the demise of birds, and they would of course be entitled to the commercial value of the birds that would have died at a certain kilogram value or rand per kilogram value, and it will also address the inefficacy portion of the claim where birds fail to achieve the required carcass value. But is there any other exposure? And of course there is. Of late we've seen that recall actions initiated by the Consumer Commission is not uncommon, and it may well be that as a result of analysis of the feed confirming that the consumption of the feed is in fact detrimental to broiler birds, and potentially then also to end users, that a recall action is necessary. And in a case like that, the cover provided under the recall section, as we've seen, are the costs involved in recalling the product from the market. So one of the requirements, and unfortunately our time today doesn't provide for an in-depth analysis of all of the requirements to be met for a recall claim to be successful, but one of the requirements would entail that the defect is serious enough to warrant the recall of a product. So what constitutes a serious enough defect? That is obviously in many instances a million rand or dollar question, because for one producer or manufacturer it may be detrimental if the color of ink on a wine label is not up to standard, and for another it's the inclusion of a potential toxic chemical in animal feed. So there's a lot of investigation necessary to determine whether it's serious enough. The next requirement, of course, would be that the product has entered the marketplace. It goes without saying that if it hasn't left the insured's premises yet, that this requirement will not be met. In the middle, the grey areas, as we call it, is of course scenarios where the manufacturer has, for instance, released some of the defective product to a distributor, but the distributor has not yet released the product to the retailers and placed it on shelves. The question arises, well, has it entered the marketplace or not? So as you can see, there's a lot of permutations of what can happen in the industry, or alternatively, if it's been placed on the retailer's warehouse floor but not yet on the shelves, it gives rise to some interesting discussions. All right, and then of course, versus the replacement or the guarantee section of the policy, where in a lot of instances, as soon as a defect is detected in broiler feed, the insured is required to immediately replace all of the feed that has already been pumped into the mini silos that I referred to earlier. So this comes at a very high cost to the insured, and in terms of the guaranteed cover provided, there would be cover for the replacement feed that is required. You would also have noted that there are different permutations. It's not just the replacement, but if possible, if the defective product is capable of being repaired, then the cost of repairs. So similar to a property damage or material damage policy, you would have at the option of the insurer either replacement or treatment or any of the other options available to rectify this particular problem. So this is where guarantee is extremely important for a manufacturer, because the replacement can also be quite expensive, as you can imagine, and eats into one's bottom line very clearly. So hopefully, by virtue of the example provided, we have covered the nature of the different sections to a products liability policy with all of its bolt-ons to provide the comprehensive insurance that is out there. And then coupled to terms and conditions that are enforceable and adequate limits of indemnity, there should be protection against financial ruin to effectively mitigate the exposure that insureds face in the manufacturing, retail, and related industries today. Another aspect that we can delve into is, of course, the Consumer Protection Act. Something that we can consider in another event if there is some interest, or we can delve into the requirements to trigger each of these different sections, and then also by virtue of examples look at what scenarios insureds face out there, look at risk mitigation exercises that can be imposed or improved on from industry experience, and make this almost a bolt-on to what we've discussed today. If there are any questions insofar as the aspects touched on today are concerned, then we are more than happy, or I'll attempt at least, to address those. Thank you very, very much.
Thank you, Jean, for your insightful session. I like the way how you used one example and expanded on there to illustrate the different types of cover. I must say, on my side, the recent claims that have been landing on my desk relating to product liability, there's clearly some sort of disconnect or misunderstanding on how the specific types of covers work to specific scenarios. So hopefully this session has given our brokers some insight into which type of cover is applicable to which situation. And also on your point to risk mitigation, it's definitely important to make sure that they have that adequate risk, adequate indemnity in place for the specific claim that might be forthcoming. I don't see any questions in our chat box. I know that we did have a technical glitch, so it doesn't appear that all our brokers could join this call. If Jean is perhaps up to it, we might have a take-two session next time. But thank you for everyone who has joined us. Take care till next time. Bye. Bye bye.